very much.
Mr. Redfield, how are you doing for time?
Pretty well, my lord, in the sense that I will be able to finish ground 4 relatively soon. Grounds 5 and 6 I will probably have covered by now, or certainly by the end of ground 4, I think. That just then leaves grounds 7 and 8. 8 is a very short point.
7 takes a little bit of time.
7 will take a bit of time, but there will certainly be ample time for Mr. Smith to reply.
Good. Well, we will try not to ask you too many questions, but you can see we can't restrain ourselves.
I know it must be difficult, my lord. I was going to move on to the priority given to the 2024s
Yes.
under the ICA in respect of the security. And I can take this quite lightly because we've already looked at parts of paragraph 306. And ultimately, in paragraph 306, subparagraph 4 on page 903, I think what the judge is saying is that his answer to this point is really the same answer as he gave and we've looked at in relation to the preservation of the maturity dates. There are just a couple of points, though, I do want to pick up on, 3. In relation to subparagraph 1, at the end of subparagraph 1, the judge says, I accept Mr. Bayfield's submission that the court should approach this question on the basis that condition A has been satisfied. That is what has become ground 6 of the appeal. Learned friends contend that the judge sanctioned the plan on the basis that he had found condition A to be satisfied. Now, in relation to this ground and this sentence, well, it rather depends how much you attempt to load in to that sentence. Obviously, one only gets to the question of discretion if condition A has been satisfied. And what I suspect I submitted is that the way in which condition A was satisfied, i.e. not only that the no worse off test was satisfied, but that everyone would be better off and on the balance of probabilities, everyone would be paid in full, was the position, i.e. that was relevant to the position as regards the differential treatment that arises by virtue of the 24s having prior ranking security. I submit that the judge was not saying that simply because condition A had been satisfied, i.e. the 29s were no worse off, that of itself was a complete answer to the question whether the giving of the priority security to the 24s was a flaw in the plan which exposed the plan to needing to have sanction refused. That is my, I think, complete response to ground 6. I thought I'd deal with it now because the paragraph is open. The other 2 points to make in relation to this, one is a terribly minor point, so I will make it first. There is an infelicity in the drafting of subparagraph 8 on page 904 that may or may not have caused your lordship's confusion, but I just want to ensure that there is no confusion. At the end of subparagraph 8, the judge says, as Ms. Toad pointed out, 65% of the plan creditors holding about 1.15 billion of the sums voted for the plan. What the judge meant to say was 65% of the plan creditors excluding the members of SteerCo holding
That was how I read it, by reference to the last sentence, yes.
And in my submission, that is the correct reading.
Clearly 1.15 billion is not 65%, it's 3.2 billion.
That's right. And it's not the submission that Ms. Toad made either. The other point, more important, is this in the context of the giving of priority to the 24s. That obviously was something that didn't only affect the 2029s, but it actually affected the 25s and 27s as well, because they too...
26s.
And 26. Yeah. They rank as well behind the 2024s under the ICA. And as we'll come on to in ground 7, let's assume that not everyone is going to be paid in full because things don't go to plan and there's an enforcement. Well, everyone else then ranks equally, 25s, 6s, 7s and 9s, but the 24s rank before them.
But the others don't rank equally. They may rank equally under the intercreditor agreement, but the nature of the management plan is you get paid out as and when you fall due.
No, my lord.
Means if your maturity date is earlier, you get paid out earlier.
That is right. As we'll come on to ground 7, the point really here is that if Knight Frank are right, or rather if the results turn out to be considerably worse than BCG have forecast, then at the end of 2024, the loan-to-value covenant will be tested and will be failed. There will then be enforcement. That will be at a time before anyone has been paid.
Yes.
At that stage, the temporal priority of the 24s is not relevant. The priority security is relevant, and all of the other Sun holders will then rank equally under the ICA, not having yet received a B.
Yep.
So, whilst there is obviously differential treatment that advantages the 24s over the 29s, it's actually a feature that affects all of the Sun holders other than the 2024s. And the judge did know in relation to this that the 25s, 26s and 27s all did vote by the statutory majority in favour nevertheless. There are three other topics I need to cover in the context of ground 4. The first is the treatment of the convertible notes. Actually, I've already made my submissions. I'm sorry, my lord, you're looking quizzical.
Yeah, I thought you'd already had a go at that, but maybe you've got something more to say on that.
No, all I was saying is I've already dealt with it in a different context, but it arises in my learned friend's skeleton argument in this context too. The next point is the new money. And what my learned friend said is that the new money was a further reason which the judge should have relied upon for not sanctioning the plan. That, assuming it's pursued as an argument, rather ignores the purposes to which the new money were going to be put.
I think he said it was very expensive.
It is more expensive than the debt which it is being used to pay off, but it does also give the group access to capital expenditure for the purposes of working on the development properties, for the purposes of improving the returns to the plan creditors.
I think when pushed, Mr. Smith effectively accepted that how expensive it was something that, if he was wrong on his pari passu arguments in relation to security and maturity dates, it didn't help him because it affected everybody equally.
Well, then I probably need to say.
I mean, I think that's a fair. Yeah. It was a bit of an arm wrestle, but I think that's where we ended up, wasn't it?
Yeah, I accepted it. It's not an independent point, independent of the preference and maturity.
Yeah.
Then all I need to say about it is that the judge dealt with it between paragraphs 311 and 321, and your lordships may want to look at paragraph 317 for the purposes of the judgment, where he accepted the new money served a genuine purpose, which was of benefit to the plan creditors. The next topic under ground 4 is the allocation of the equity, something that my Lord Justice Nugee wanted to hear submissions on. The argument is that the judge should have refused sanction because the current shareholders in the group retain 77.5% of the equity. It's said that there's no justification for that retention because in the relevant alternative, the shareholders are entirely out of the money. Now, the judge agreed with the appellants that there was no compelling logic justifying the shareholders retaining any equity. That's paragraph 324, but nevertheless considered it appropriate to sanction the plan, which is paragraph 326. Now, this was a point on which we put in a respondent's notice, which I suspect your lordships have seen. I probably don't need to go to it, but it's at tab 8 of the core bundle. It was filed on the basis that we contend that there is justification for retention of the equity by the shareholders in this case. First, if the plan works out as anticipated, all of the note holders will be paid out in full with interest. In that event, they've had everything to which they are entitled to, won't have had to take any haircut, and can have no right or expectation to anything more. Many plans and schemes do require creditors to release their debts or parts of their debt. This plan does not do so. Conversely, there are many schemes which carry out an amend and extend transaction, as it's often called, whereby the maturity dates of the company's debt instruments are extended without there being any release of the principal in whole or in part. And so far as I'm aware, it's never been suggested by the judges in those types of cases that all of the equity needs to be allocated to the financial creditors as the quid pro quo for the amend and extend, notwithstanding that the comparator and the reason why the amend and extend is necessary is the financial difficulties of the company, which often mean a liquidation comparator.
It's not actually just allocated. I think the logical, and perhaps I can put this to you, but Mr. Smith can listen to it, because in a sense it's something that occurred to me having risen after last night. The argument as I understand it is that it's unfair to all creditors who bear the risk of the plan failing, that shareholders should retain their equity. So it's not a question of allocation of equity, it's a question of is it fair that the shareholders retain their equity? And Mr. Smith said in the situation we're in where the value breaks in the unsecured creditors and the relevant alternative, they are effectively the economic owners of the enterprise, and therefore shareholders shouldn't be allowed to retain their equity. What that actually means, putting it rather more bluntly, is that in order to be fair to creditors, shareholders should be deprived of their existing equity, shouldn't be allowed to retain it. I don't at the moment see any mechanism by which that could be properly done, because a plan under Part 26A has to be a compromise or arrangement between the company and it's either its creditors or members. Under the old mechanism, you didn't compromise with members, you just left them behind in the shell in the examples that we looked at. If what Mr. Smith is saying is right, I think in effect he's saying that in every plan of this type, there should be a provision by which the existing equity is expropriated and redistributed amongst the creditors who are the economic owners of the company. I don't see how that fits within the definition of a compromise or arrangement, and this is a joust that Mr. Smith and I have had on a previous occasion, where I didn't need to decide it. And Mr. Justice Richard Smith, I think, has said subsequently in a case that one can, in effect, have a compromise or arrangement where somebody who is no worse off is given nothing.
Right, so.
And I raised the question whether that's right.
Yes, well, that's not an issue I think needs to be decided in this case. There is a tension, just to discuss it, there is a tension between the idea that you don't have to have even a meeting for someone who's entirely out of the money, but they can still be bound. And the basis of that is that they have no genuine economic interest.
But they're missing the point. The whole thing is there still has to be a compromise
Well,
or arrangement.
That was the tension. So that's the starting point. But you still have the words compromise or arrangement within Part 26A, which have the meaning that they're given under Part 26, which means some form of give and take. That is the tension. I can well see the argument that you cannot enter into an arrangement with someone who is entirely out of the money if you give them nothing, because that's expropriation and that is not an arrangement. Yeah. And therefore, you either need to leave them behind and transfer all of the assets into a new co. If they're going to be, then they don't need to be subject to the plan. But if they're going to be subject to the plan and bound by it, then there is that very real issue as to how that can be achieved without giving them anything.
Yes, and my understanding of Mr. Smith's submission is that this plan should have provided, it should have been with the members and should have been provided for their equity to be transferred from
Of this Mr. Smith, yes.
correct.
So
From the, yes, although the two Mr. Smiths joined forces, I think, in the other decision. 'cause
They
one-
did. The
one
other
managed to-
decision-
one managed to persuade the other.
the other decision is
Sorry,
this
sorry,
aspect
Sir,
is
Sir Richard Smith was persuaded by Mr. Smith.
in one
I see.
paragraph of his judgment. There's not a huge amount of reasoning. It's a pretty
You don't have to agree with
practical.
me if you don't agree with me. If you know what I mean. I think obviously you know that. But it did strike me, and I'm really sort of saying it to you. I mean, it seems to me that Mr. Smith's submission raised that. It probably raises some other points that you will have in your armoury to answer. But it seemed to me to raise that question as well.
Yes. Well, I accept that. I think that is right. There's certainly an issue. It is hard to see how there is an arrangement with someone who is given nothing unless the word arrangement means something different in Part 26A than Part 26, and there's nothing to suggest that that's what the legislature intended.
Yes, because I think the authority, is NFU Mutual, where it was simply said a mere expropriation is not a
Yes.
compromise or arrangement.
And there are plenty of other authorities, as my Lord knows, including Miss Justice Hilliard in the Lehman scheme, that look at the concept of arrangement and do say, well, it's very broad, but boiled down, there has to be some give and take. And if you just have take and no give, that would appear not to be an arrangement. As I can show you the paragraph in Prezzo, but there's not sufficient analysis in it that it's probably helpful to do so.
Yep. Anyway, I thought I'd raise it since you were raising it at this point, because it gives Mr. Smith a chance to think about it before he stands up in reply, because I'm afraid I wasn't. I was so dazzled by the way it was put yesterday, I didn't really think of the answer to what was being put before us.
Okay, the other point is, in this case, you have to think about how it would be structured, because getting equity in the plan company isn't necessarily going to do the plan creditors much good.
Land company doesn't have any assets.
That's precisely the point.
You can't
So,
issue. I mean, the problem is, Mr. Smith is talking about it's the shareholders retaining their equity is what he's complaining about. If there's an allocation of new equity, that would have to be done not at a discount for a start. And it would be a different.
well, it wouldn't be equity in the plan company.
Where's the
That's the point I was trying to make.
22.5% going to new money lenders? What's that equity in the parent company?
Yes,
Yes.
yes. That's really the point.
I mean, my understanding is that, and obviously we can look at it, but my understanding is that the opposition, the alleged unfairness, as Mr. Smith put it, in a situation where the value breaks in the unsecured and that shareholders are out of money, they shouldn't be allowed to retain their equity. They shouldn't be allowed to retain their equity because, in effect, it gives them a potential interest in the future in the event that everybody is paid in full, and the only people who've taken the risk of that, he says, are the unsecured creditors. And he says that's unfair. So the proposition must be, I think, that it's unfair to unsecured creditors for the shareholders to retain their equity. Ergo, my understanding is his argument is that they have to be deprived of their existing equity. This has nothing to do with new equity.
Well, I'll leave him to deal with that point, but this is a slightly special case. What I've dealt with so far is that if the plan goes to plan and all of the creditors get paid in full, they're getting their principal, they're getting their interest, they're not taking a haircut at all.
Well, that was the point we were debating yesterday, which is, in a sense, how can they possibly complain? They've had the full satisfaction of all their legal interests.
And if the plan doesn't go to plan, and they don't get 100p in the pound plus interest, then there is no value in the equity at all.
Absolutely.
Because all the equity is a right to the surplus after the payment in full of all of the plan creditors.
Yeah. But what Mr. Smith and I understood that, and I think that was what my Lord Justice Nugee and I were putting, as it were, as a double act to him, because I think that we were on the same page about that. But I think his answer to that is yes, but that ignores the fact that where there is a relevant alternative of insolvency and value breaks in the unsecured creditors, the economic owners, as he would put it, of the enterprise are just the creditors.
Yes, but he can't have it both ways. His entire case is built on where you look at the relevant alternative and what would happen, and this has to replicate that. In a liquidation scenario, if there were enough assets to go round and the creditors get paid in full with statutory interest, who is it that's entitled to the surplus? Well, it's the shareholders. So if one's replicating the relevant alternative, or that's the starting point for the framework, or however it's put, well, then it's somewhat perverse in a situation like this, when the creditors are not taking a haircut, there isn't ongoing business, there's an asset disposal programme. It makes no sense for the creditors to say, well, shareholders, you're out of the money, we're the economic owners, so we will want payment in full if there's money available, together with a surplus that we'd never be entitled to in the liquidation because you're out of the money in the relevant alternative. But that is the case that's against me. And your lordships reacted somewhat quizzically to whether that could possibly be the right answer. And my submission is it's not the right answer. The creditors either get everything they could be entitled to, and the shareholders in that event get the surplus, or the creditors don't and there is no surplus and the shareholders get nothing. And that is a replication of the position in liquidation and entirely appropriate. The plan creditors, let me put it another way, the shareholders at parent are not retaining their equity at the expense of the plan creditors. Because it only has value if the plan creditors' rights are vindicated in full. And as I said, in the amend and extend examples, there has not been anything other than, as a general approach, a retention of the equity by the shareholders. So all of those cases would, in a sense, have been wrongly decided because this idea of the restructuring surplus is not one which is, in my submission, specific to plans and inapplicable to schemes. My Lord, that is, unless your Lordships have any questions for me, ground 4. Ground 5, I think I've really already covered. Ground 5 is that the judge treated the overall vote of creditors as being decisive or a very weighty factor. The ground is based on paragraph 302, subparagraph 9. We have debated it, and I've explained, with reference to the submissions that were made, how that subparagraph should, in my respectful submission, be construed. And I've taken your Lordships through the voting and the points that we make off the back of that. And that's probably, therefore, all that I need to say about ground 5.
I mean, at some point, though, you need to cover, maybe you actually say you probably have covered it. I mean, is there anything else you want to say about the adequacy of the explanatory statement in relation to any of the issues we've thus far covered?
Well, my Lord, I can take you through the highlighted sections and explain what they say, if that would help.
Well, in a sense, I can read them. I'm interested in, I don't need you to tell me what they say. I want you to tell me, the argument that you face, that Mr. Smith advances to buttress his, I think it's a buttressing argument, that you can't rely upon the support of plan creditors in the way the judge did on the question of no pari passu, no adherence to pari passu, because the departure from pari passu was not drawn to the attention of plan creditors, even though they're sophisticated, as it should have been. I think that's a fair summary of the way in which he supports his proposition. Yes. About departure from pari passu with saying you can't rely upon ground 5, the votes of creditors. So it is important to make sure you've had your full say on the explanatory statement.
Well, let me say this then. In my submission, no plan creditor who read the explanatory statement and the BCG report can realistically have failed to understand that in the context of the relevant alternative, they would be treated equally, and that under the plan, they would be treated differently because their maturity dates other than the 24s were being retained. All of that information is undoubtedly within the explanatory statement and within the BCG report. The question, therefore, is whether there is anything deficient in the explanatory statement, because it doesn't say in bold terms, by the way, you are not being treated equally in the plan, whereas you would in the relevant alternative.
So, for example, under the heading risk factors, in the risk factors section, no attention was drawn to the greater risk that the 2029 holders bore under the plan than other sons.
No, what it says is that there is a risk that property realisations will be at a lower level than has been forecast.
Yes, please.
I'm trying to answer my Lord's question. That's as far as it goes. But if you are a 2029 note holder, just as when you buy a 2029 note in the first place, you know that if things go badly, you're at greater risk than a 27 who's at greater risk than a 26 and so on. As a sophisticated investor, you will appreciate what that means for you. And one can test it in this way. It's not as if Mr. Smith and his clients were wholly unable to come to court to complain about the differential treatment because there wasn't a sentence in the explanatory statement that made the point that my Lord has just suggested should be in it. One needs to tell people what they need to know, taking into account their level of sophistication. But one doesn't need to spoon feed to the extent that my Lord is suggesting. And I would submit that it is not a deficiency in the explanatory statement that it didn't say in terms that if you are a later maturing note holder, you are at extra risk in relation to the property disposal prices.
I think the way it is put is slightly more nuanced than that. It's not said as a freestanding ground of appeal. The judge should not have, unless I've missed it, it's no freestanding ground of appeal to say the judge should not have sanctioned the plan because the explanatory statement of itself was so defective that it just failed the basic jurisdictional requirements.
It said that the court can't be satisfied that the creditors were told what they needed to, such that you can't rely on their votes.
I think it's used, primarily, and again, Mr. Smith will tell me if I'm wrong, but I think this was primarily used as a justification for undermining the weight which the judge gave to the affirmative votes in the various classes. Because on the point of complaint, it's by no means clear that it said that the affirmative vote would have taken into account this point.
Well, any plan creditor that bothered to read the documentation, including the fact that the AHG had alleged that the plan results in unequal treatment of pari passu creditors, would have understood what the plan
Yes, but they would have then gone on, if you'd have read that paragraph, and you need to give me the reference, it's 647, I think it is.
647, page 40.
To be told, but don't worry, because the plan is fair, because you'll all be paid out. What does it say?
It's at the foot of page 40 of the extracts that we handed up.
Yes,
confident that the restructuring plan treats all classes fairly.
and leads to materially better recoveries than the relevant alternative. So in a sense, it was just a bland answer, in fact directed at a different point. It didn't actually deal with the actual thing didn't deal with the point. It just said it's fair and you'll get more than in the relevant alternative.
Well,
It didn't.
that's right, and that's what the judge ended up deciding as well. But ultimately, the question is the court unable to rely on the positive vote of the 2029s because they thought they were voting on something which they weren't or hadn't properly understood what the plan did? And I think with respect, that's somewhat underestimating the plan creditors. And as my Lord Justice Nugee pointed out, one can see precisely what happens in the BCG report in terms of when people get paid. And given that this plan was being promoted in circumstances where there was financial distress and there was going to be a 63% return in a liquidation, you don't have to be the greatest investor of all time to understand that that may mean something different from a 29 than a 24.
But for example, if you're a pure note holder in the 28 or 29, I think it is, that you place reliance on, holding only the bare minimum 100,000 notes, that's an analysis that you might well not have pursued. You might have just read that and thought, oh, okay.
Well, what you might have read or what you might have stopped after reading is that the expectation is that you'll get a better return. That may have been good enough for you. Ultimately, the exercise of the discretion was, well, everyone's going to be better off, and on a balanced probabilities, you're going to get paid in full, notwithstanding the differential treatment. And I think it is unrealistic to say that the court shouldn't place weight on the positive votes in favour of the 29s, including someone with over 30 million of 29s and a chunk of 2017s as well, because the explanatory statement wasn't drafted in the way that my Lord suggests it should have been. Now, people will take away from the judgment in this case whatever is said about what needs to be in an explanatory statement. But I simply don't accept that you can't place reliance on the positive votes because of the way that the explanatory statement was presented.
Was I wrong in Sunbird?
Sunbird was a very different creditor constituency.
In the passage that I need you to just address, Mr. Smith on this point relied upon what I said in Sunbird about the and indeed in Virgin Atlantic, about the need to explain why certain creditors are given preferential or better treatment than others. I need you just to address whether what I said in either of those two cases is, and feel free to have a go if you think that I spoke too strictly, rigorously, or otherwise.
That's certainly the ideal. And the approach to an explanatory statement where one is dealing with less sophisticated creditors, in that type of situation, it is essential that one doesn't assume too much knowledge or sophistication. And for example, in the retail schemes where there are schemes for redress payments and that sort of thing, explanatory statements are drafted very differently. They're concise, they're simple, the language is dumbed down, and you would expect them to be told everything that they might not be able to glean for themselves. I'm not suggesting that in a case such as this, it's not the job of the explanatory statement to explain what the plan does and how it affects people differently. But this explanatory statement does do that. What it doesn't do is say that you are at greater risk if you're a 29 than a 27 and so on and so forth. But I would suggest that in relation to that, it's stating that would be to state the blindingly obvious. In terms of the differential treatment, it's again blindingly obvious that there is differential treatment. The judge found no compelling reason to justify the differential treatment. Therefore, on that point, if that's right, there's nothing that the explanatory statement could have said other than potentially saying there is no compelling reason for the differential treatment, which I think my lord is suggesting perhaps should have gone there. I would suggest that probably goes a little bit too far.
We've all been assuming that the plan creditors are sophisticated. Is that just a matter of judicial notice?
I think so. Can I check whether there are any specific requirements for investing in these notes?
I don't think there are. It's just you have to buy them in minimum units of €100,000. So it's either financial institutions or wealthy private investors. I suspect is the reality.
I can't add anything to that. People that are investing in unsecured notes issued by a German real estate company at a minimum level of €100,000 are likely to be sophisticated investors, because a non-sophisticated investor is highly unlikely to make an investment at that level of this type. Unsophisticated investors will invest in perhaps FTSE 100 shares or tracker funds or premium bonds or savings accounts. They're not going to be buying unsecured notes for €100,000 minimum denomination. So yes, it's judicial notice. Can I move on to ground 7, please?
Yes.
Ground 7 of the appeal is that the judge was wrong to take into account what has been described as the company's alternative case in finding that the no worse off test was satisfied, because the alternative case is flawed. Now, just by way of overview, we say that in being satisfied that the no worse off test was met, the judge's primary basis did not take into account the relevant, the alternative case. So the ground fails at that level. I'm not going to, though, leave it there, because it's clear that what the judge did do was take into account the alternative case in the context of the exercise of his discretion. So to say nothing about the alternative case, I think, would be unhelpful. Having said that by way of overview, can I say that the use of the term alternative case should be treated with some caution. It's also important to understand what role the alternative case played in our submissions and the judge's analysis. Now, the first point, and I've already made this, is that in reaching the conclusion that the 29s were no worse off, the judge determined on the balance of probabilities that they would be repaid in full. That's paragraph 290. I'm not going to take you back to it. The judge said in terms that the no worse off test was also satisfied with reference to the alternative case. It was an additional reason. He was also satisfied, but it wasn't the primary reason, and it wasn't essential to the satisfaction of condition A. Now, the basic purpose of the judge's reasoning was, when he's looking at the exercise of discretion, that there was necessarily some uncertainty in the trajectory of the German property market. The judge pointed out that he didn't need to conclude that the 2029 notes were likely to be repaid in full to satisfy the no worse off test, but he was satisfied of that anyway. The judge gained additional comfort in relation to the satisfaction of the test and, more importantly, the exercise of discretion from the alternative case. And I'm going to move on to that in due course. But before I do so, can I just explain why I say that the alternative case is a slightly misleading label? At 293, as we've seen, we probably don't need to go back to it, the judge held that the least likely outcome from the plan was the doomsday scenario modelled by Ms Rickleton on behalf of the AHG, who suggested that 29 notes would only recover 10.6%, being the PIK interest payable in 2025. That was based on A, Knight Frank's valuations of the group's assets turning out to be correct, B, all of the proceeds of sale being distributed to repay the early maturing notes, and C, that resulted in nothing being left over by the time that the 29 notes matured, resulting in catastrophic losses for them. Now, the judge pointed out that doomsday scenario was flawed in a number of ways, and in order to illustrate the flaws, the judge considered in considerable detail what would be likely to happen if Knight Frank's valuations turned out to be correct. And he did that as an exercise of sort of testing the doomsday scenario and seeing what was more likely, but using the Knight Frank valuations as the sort of base test, notwithstanding that he had already rejected them. So this isn't an alternative case in the sense we say, well, if it's not the BCG prices, it's the Knight Frank prices. This is, even if it's the Knight Frank prices which are wrong, that doesn't lead to the 10.6% return to the 29s. As I said, the judge had already rejected the Knight Frank valuation evidence at paragraphs 167, 175 and 217. So the critical conclusion he reached in relation to this is at paragraph 281. Can I show that to your lordships, please? What he says is that if the future valuations set out in the Knight Frank report turn out to be accurate, then the plan company and the parent company will be in breach of the LTV covenant in the 2029 notes, and the 29 plan creditors will be entitled to serve notice under clause 10.2, declaring that their debts are immediately due and payable. They also find that if this occurs, then the likely outcome is that all of the plan creditors will serve notice under clause 10.2 and will form an instructing group to instruct the security agent to enforce the transaction security under the intercreditor group by accepting a credit bid from a signed BidCo, resulting in an orderly wind down and sale of the group's assets. Finally, I find that in that event, the likely outcome is that the net proceeds will be distributed ratably and on a pari passu basis to all the plan creditors. Now, he must mean all the plan creditors other than the 2024s there, but the point he is making, and I'm going to unpack all of this, is that the 2025 to 2029s would share equally in the proceeds of realisation of the properties realised by sales from BidCo, which would have been used to acquire the properties on their behalf.
Sorry, just give me that reference again. I missed where you were reading from.
281.
Thought that, yes, you say that what he must mean is other than the 2024s.
Yes.
Although Mr. Smith actually says you can't assume that that's what he means, because he seems to have forgotten that the 2024s actually have security. Why do you say we can assume he meant other than the 2024s?
Well, because if the 2024s have prior ranking security, they get paid first.
Well, I know. That's exactly the point Mr. Smith made. The judge seems to have forgotten that was the case and thought that acceleration was a cure for all disparity of treatment.
But he, with respect, he must have thought that he was referring to the 25s to 29s. He can't realistically have forgotten that the 2024s don't have prior ranking security.
He's just said in 280, once the secured creditors are paid off,
And in 285, he refers to after repayment of the 2024 notes.
Okay.
So, both of those paragraphs are the same page or the next page to paragraph 281.
Right.
So in the Knight Frank valuation scenario, what the judge held was that the 29 notes and the other notes other than the 24s would likely be accelerated long before their contractual maturity dates, and that an acceleration would likely lead to an enforcement scenario in which the plan creditors ranked pari passu. Now, that, of course, if right, would avoid the doomsday scenario contemplated by Ms. Rickleton, in which the earlier dated notes recover in full at the expense of the 27s and the 29s. And it's that, the analysis that, in fact, that doomsday scenario would not come to pass, that the judge refers to as the plan company's alternative case. But what it actually is a response to the evidential case that the Ad Hoc Group had presented the court with. It was designed to show why Ms. Rickleton's doomsday scenario was unrealistic and highly unlikely to occur. And Mr. Smith complains that the alternative case wasn't set out in the explanatory statement, but the alternative case was a response to the evidence that was filed by the Ad Hoc Group after the explanatory statement had been circulated. And in any event, the plan had been devised to give these protections to the 25s to 29s in case things didn't go quite to plan. And all of the elements of the alternative case are in fact contained in the explanatory statement. So what I'd like now to do in terms of ground 7 is...
Sorry, did you say that the acceleration provisions, that's right, you say the default...
The LTV covenant, the acceleration provisions...
had been designed to provide protections to the 2025s to the 2029s in the event of the value.
That's why they've been included.
Okay. Was there anything in the explanatory statement in that context?
Yes. Learned friend will give us the reference shortly. Yes, have you got the extract that we handed up this morning?
Yeah.
What, the one
that's highlighted. That's the one.
Yeah.
It's page 100 of that, paragraph 2.2. So about, I think it's 4 pages from the back of the clip.
Sorry, I'm afraid I've already put it into my bundle. So.
Page 100.
Yeah. Okay, so it doesn't in fact make the point. Sorry, I was wondering whether it actually said something along the lines of what you've just said to us, namely that the purpose of this is to protect the lower ranking note holders by allowing them to accelerate to put everybody on a pari passu basis. But it doesn't.
Well, I would say that was self-evident. Well, do remember that the security that is granted to the sons is granted through the plan. All of this is new because at pre-plan they are unsecured notes, and the security is there for the benefit of them and others, and the provisions that are being looked at are directed to what they can do.
Yeah,
so
I was only wondering, you know, as it were, musing that in your favour, as it were, something rather more specific might have been said along the lines you just submitted to us here.
It says what it says, my lord.
Yeah, okay.
I was going to deal with 2 points now. The first point is I'm going to explain why the judge was right to conclude that in the Knight Frank valuation scenario, the 29s would likely be accelerated long before their contractual maturity, and that acceleration would lead to an enforcement scenario where there's pari passu ranking 25s to 29s. And secondly, and in light of that, I want to address whether the plan creditors would in fact be no worse off in that scenario than in the relevant alternative, because that was part of the reason why the judge exercised his discretion in favour. So starting with the first point, the judge analysed this in 2 essential steps. Firstly, the judge held that in the Knight Frank valuation scenario, the plan company would breach a loan-to-value covenant, that's the LTV covenant, on the first day when it's tested, which is the 31st of December 2024. Now, that would then constitute an event of default, such that each and every 2029 note holder would be entitled to accelerate its 2029 notes. And for what it's worth, there's a helpful summary of the LTV covenant in paragraph 42 of the judgment, and if you want it, the full LTV covenant is in fact set out at paragraph 218. Well, can I just go back on the explanatory statement, not highlighted on the hand up, but on page 40 at paragraph 6.45c, there is a summary of an explanation given by White and Case to the Ad Hoc Group's complaints. And at C it says the Ad Hoc Group's criticisms of the restructuring were misplaced and overlooked significant important protections which will be afforded to the Sun holders, including the 29 Sun holders, including but not limited to the proposed LTV maintenance covenant that is to be introduced by the proposed amendment.
Sorry, just give me 1 second here, because yeah, okay. It's curious that paragraph 6.44 must refer to the letter in greater detail, presumably.
Your Lordship has the benefit of having the whole document.
Well, I don't actually. Not, well, I might have it somewhere there, but
We do have copies. If you'd like a hard copy, you have a full.
No. I mean, but I'm assuming that 644 says.
Well, I'm going to have a look myself.
Paraphrases the AHG's letter. It's just the subparagraph to which you've referred us starts. The AHG's criticism of the restructuring were misplaced. I'm just wondering what those criticisms, what it's responding to.
It's responding to a letter that White and Case received.
Yes, I get that.
I am. Paragraph 644 reads as follows, although there's other correspondence that is recited beforehand. On the 19th of January 2023, Millbank, Hengeler and Houlihan Lokey, on behalf of the SteerCo, confirmed in a letter to the parent company, the plan company in White and Case, that in light of, amongst other things, the existing obligations under the lock-up agreement and degree of support for the parent company's proposed restructuring, the SteerCo considered the AHG's alternative proposal to be incapable of implementation. Now, to put that in context, there had been a proposal made by my learned friend's clients for an alternative plan, which in fact did not take a pari passu approach, but you can see from here wasn't one that was supported. And that's what 644 says, and then 645 follows that. But actually, I mean, one really needs to read from 6.41 where the correspondence is summarised.
Okay.
I would invite my lord to do that. I just told your lordships where you can find the LTV covenant. Picking up there, as the judge explained in paragraph 219 of the judgment on page 864, two of the planned company's witnesses, Mr. Trotsey and Mr. Wolfe, both gave evidence that in the Knight Frank valuation scenario, the LTV covenant would be breached on the 31st of December 2024, when compliance with it would be tested for the first time. The judge accepted that evidence, and Mr. Smith didn't challenge it in cross-examination. One sees that in paragraph 220. It's common ground that a breach of the LTV covenant would be an event of default and would entitle each 2029 note holder to serve a notice of acceleration if the breach of covenant wasn't remedied within 40 days. One sees that from the judgment at 221. And then can we leap forwards, please, to paragraph 267 and the judge's conclusions on this.
Just to be clear, when you accelerate the 2029 notes, does that automatically result in a cross-acceleration?
No, but the reality is, if you're a 27 note holder, or 25, or 26, if the 29s accelerate, you're going to accelerate as well, because you don't want to end up temporally being subordinated behind them.
Yeah, so even if not automatic in the sense of written into the documentation, you assume that everybody else will.
Exactly.
Right, thank you.
Can I ask your lordships to read paragraphs 267 to 268, please, to yourselves? These are the judge's conclusions on the point. Now, there's no challenge to those findings in my learned friend's grounds of appeal. In fact, they only mention the LTV covenant in one place, I think, in their appeal skeleton. It's important to understand, though, the impact of this point. It's common ground on this appeal that in the Knight Frank valuation scenario, each 29 note holder would be entitled to accelerate its 29 notes by the 31st of December 2024. In other words, in the Knight Frank valuation scenario, which is, of course, the Ad Hoc Group's own evidential case, the maturity dates of the notes would be, for the 25s to 29s, irrelevant. Now, the 24s obviously get repaid in priority because of the prior ranking that they obtained through the intercreditor agreement. But that's a function of the intercreditor agreement and not actually the maturity dates of the notes. And therefore, on the AHG's own case, the different maturity dates of the notes would have no practical impact whatsoever, since they'd all be accelerated before any of them became due. Now, the LTV covenant was flagged in the explanatory statement. It's part of the commercial bargain that the plan was designed to implement. Can I just show you another reference to it, which is actually in the supplemental bundle behind tab 1A. And it's page 106, letter O. Actually, it's. I apologise. It's on page 100 of the handout, so you've already looked at it. So you've already seen the reference to the LTV covenant and what it's doing there from the explanatory statement. Now, the appellants make a point in their appeal skeleton at 55 subparagraph 3 regarding a separate covenant in the new money facilities agreement referred to as the release price mechanism. Now, my Lord's heard submissions in relation to that. I refer to it as the RPM from Mr. Smith. The RPM states that the group shall not sell yielding assets at less than 20% of CBRE's valuations as at the 30th of June 22, and shall not sell development assets at less than 30% of Apollo's valuations as at the same date. The clause is referred to in paragraph 233 of the judgment. As my learned friend told your lordships, the RPM can be waived by a majority in value of the new money lenders. So not the note holders, but the new money lenders. And the judge accepted Mr. Smith's submission that the new money lenders would be likely to waive the RPM if that were necessary to allow the group to make a sale at a fair market price. Mr. Smith's submission is recorded in the judgment at paragraph 258, and the judge's analysis is at paragraphs 263 to 264. And in reliance upon that, what the appellants now say is that the assets would likely be disposed of in order to repay the new money lenders before any alternative enforcement scenario could take place in 2025. Now, that may be correct as far as it goes, but the appellants are wrong to argue that the potential waiver of the RPM should have led the judge to conclude that the alternative case was flawed. And that's what they say. It's true that if the RPM is waived, then some of the group's properties could be sold to repay the new money in 2023 and 2024 at lower prices than those forecast by the group's advisors. But the fact remains that the LTV covenant would still be breached at the end of 2024, and at that point the notes would be accelerated, and again the maturity dates would become irrelevant. And therefore at that stage, save for the 2024 notes, all of the notes will be on an even footing. So that was the first part of the judge's analysis in relation to what we'll call the alternative case, but with the warning that I gave my lords in relation to that. The judge then looked at the likely enforcement scenario. So we're in a position now where at the beginning of 2025, the LTV covenant having been tested, all of the notes are accelerated. One possibility at that stage is complete chaos. And my learned friend said, well, why is the position any different than the position that is said to be the relevant alternative in relation to the plan? Surely the company would just go into liquidation. The difference, of course, is that pre-plan, all of the Sun holders have no security. Post-plan, and therefore in our hypothetical scenario at the beginning of 2025, they have security in the form of the security granted pursuant to the terms of the plan. And therefore it is...
But it's third ranking security.
Yeah.
So they're behind the new money. And
Behind
they're
the new
behind
money.
the 2024s.
Yes.
Are you at some point going to deal with the point about potential revocation of the acceleration?
I'm going to deal with the acceleration as ground 8, which is where it's raised, if I'm answering my lord's question.
I think probably, yep.
So what happens at the beginning of 2025? Is it the complete chaos of a liquidation in circumstances where there is now this security package over the relevant assets? And what the judge said, rightly in our respectful submission, is that in that situation, wiser heads would prevail and an orderly enforcement process would occur. And that's obvious in a sense because the note holders are going to want to avoid the stigma of insolvency and the insolvency discount. And at this stage, they would be able to do so by enforcing their security which is not the position that they would have been in pre-plan because they had no security. Now, an orderly enforcement process wouldn't involve a fire sale of the underlying properties. The judge was persuaded it was likely to involve a credit bid. The security package, which the sons hold post-plan, includes pledges over the share capital of various Luxembourg holding companies. And share pledges of that type, as your lordships will know, are often used in structured finance. They're designed to ensure that in an enforcement scenario, the underlying assets themselves don't need to be sold, which might be messy and tax inefficient. Instead, that the share capital of the holding company can be sold, typically to a vehicle owned by the financial creditors, often known as a BidCo. The new BidCo entity can then sell the underlying assets over time in an orderly manner and not in the context of an insolvency scenario. Now, I'd like to show my lords two paragraphs of the judgment that help with this. The first is paragraphs 247 to 248, just to go back to Mr. Trotzi's evidence. Could you please read paragraphs 247 to 248 and the extracts from his evidence there? The next paragraph I need to take you to is paragraph 180, where expert evidence was given in relation to this. Could my lords please read paragraph 180 to yourselves on page 838? This is evidence that in the BidCo scenario, no insolvency discount should apply, and that's the reason why the secure creditors would likely have gone for it. Now, the judge accepted Mr. Trotzi's evidence at paragraph 272 and Mr. Gunter's evidence at paragraph 274. And can I ask your lordships, please, then to read paragraphs 275 to 277 on page 890, please. One further thing I should say in relation to this is that although the security ranks behind the new money and the 2024s, that the instructing group for the purposes of an enforcement would in fact be the sons. One sees that from paragraphs 239 to 241 of the judgment. So the fact that they rank behind others doesn't prevent them from giving instructions for the enforcement to take effect. Now, Mr. Smith advanced many different reasons before the judge in the hope of showing that the credit bid enforcement structure
Wouldn't the prior ranking security actually seek to take over the enforcement?
they're not entitled to, my lord.
Okay.
And I'm told one can see that from the way that Mr. Smith posed a question at paragraph 250. But
You could read the question.
It's a liquidation.
could you read the first question in paragraph 250 to yourself, please, my lord?
Sorry, maybe I'm just being dim, but you've got three sets of security.
I think you've got one set of security.
Well, sorry, okay, you've got one set of security, three in priority, the new money, the 24 sons, and the other son holders.
Yes.
You're saying that the other son holders, in the event of default, could accelerate and enforce the security.
Yes.
And I'm questioning whether, and you said they would have control of the process. And I'm
Yes.
wondering why the security documentation wouldn't provide, as it normally does, that in that situation that actually, why do they have control of the process?
That's what the documents provide for.
And not the prior ranking security.
Because it gives them as lower ranking security holders protection.
Right, so the assumption is because that's where the value is going to break, they have the most to lose, therefore they are the ones entitled to control the enforcement process.
Perhaps, but contractually that is
Okay.
the right that they have.
Okay.
The judge dealt with Mr. Smith's attack on the workability of this in paragraphs 272 to 280. I don't think I need to take my lords through that, because on the appeal, the appellants seem to focus on a rather different point. At paragraphs 55.4 and 55.5 of their skeleton, they say that the group companies would necessarily collapse into a formal insolvency process if the notes were accelerated, even if the credit bid enforcement structure is the most likely enforcement option. They say that the relevant alternative is a formal insolvency process, and the same formal insolvency process would logically occur if the notes were accelerated as part of the credit bid enforcement structure. Now, we take issue with that. In a credit bid enforcement scenario, financial creditors can and frequently do grant waivers and forbearances to prevent a disorderly insolvency process from occurring. The share capital of a holding company can be transferred to a creditor-owned BidCo, which can then sell the underlying properties in an orderly manner in any event. And as Mr. Gunter said, and I've shown you paragraph 180, a change of control to a BidCo does not cause the same reactions as one would experience in insolvency. The opposite is the case, as external stakeholders consider that such a move stabilising. And the judge accepted that in paragraph 274. So actually it's only realistic to assume that the financial creditors would want to avoid a formal insolvency process if the financial creditors have, as they do in this case, a comprehensive security package that enables them to control and acquire the group's assets, and which lays down clear voting rules so that one knows who the instructing group is, and so on and so forth. Now, in the relevant alternative, we are in a completely different position because none of the note holders have any security at all. And in that scenario, there obviously would be a disorderly sale process or a sale process in a liquidation giving rise to the insolvency discount that the judge held would exist on the basis of the expert evidence that he had heard. Now, that is why the judge was right to test the Knight-Frank evidence and the FTI modelling based on it with reference to an enforcement scenario. Now, that's of course of itself not a complete answer. One then needs to look at how the 2029s, and in fact the 2025s to 29s, would fare in that scenario. Now, the Ad Hoc Group argues that the judge had insufficient evidence on which to conclude that the plan creditors would be no worse off under the plan in the Knight-Frank valuation scenario than in the relevant alternative. And at this stage, it's important to reiterate that the judge held that the Knight-Frank valuation scenario was not the most likely outcome. He'd in fact rejected the Knight-Frank evidence. It was never incumbent upon the plan company to demonstrate that the no worse off test was satisfied on an assumption of the correctness of the valuation evidence which the judge rejected. And it's not necessary for us to satisfy the no worse off test in that way with reference to the rejected evidence. The plan company was, of course, under an obligation to satisfy the no worse off test, and that was satisfied in the way that I explained to my lords with reference to it being on a balanced probabilities likely that everyone would be paid in full. And the Knight-Frank valuation scenario is one of many, an infinite number of different possibilities in terms of the values that could ultimately be achieved, because as my Lord Justice Nugee said, one can adopt the BCG report, but the one thing you can be very confident of is that the precise number that they arrived at is unlikely to be the correct one. The plan company can't possibly deal with the no worse off test on an infinite number of possible valuation scenarios. It was satisfied on the valuation scenario that the judge accepted having heard evidence. And that's why it's wrong to suggest, if it is being suggested, that there was some sort of burden on the plan company to discharge the no worse off test with reference to the Knight-Frank valuation evidence. Now, the problem that confronted, we say, the Ad Hoc Group in this regard is that the judge accepted Mr. Gunter's evidence that a sale of real property in a German insolvency proceeding would be likely to produce an insolvency discount of between 23 and 25% as compared to market value. That's paragraph 184 of the judgment. The judge also accepted his evidence that no relevant insolvency discount would arise in a credit bid enforcement scenario followed by an orderly sale of the underlying property portfolio. That's paragraphs 180 and 274. And there's no challenge to either of those findings on appeal. And as a result of that, there is an unbridgeable gulf between the likely outcome in the relevant alternative and the likely outcome in a credit bid enforcement scenario, which the judge held would occur if Knight-Frank's valuations turned out to be correct. And the overall effect of the application of the insolvency discount would be to reduce the returns to the holders of the notes by 1.6 billion euros, comprising a discount of 500 million to the gross asset value of the development assets and 1.1 billion to the gross asset value of the yielding assets. And one gets that.
I think the judge puts it the other way around, but that's a mistake, isn't it? Paragraph 178. did look very odd. Or is that the right way round?
I think that's right.
No, I think that is the right way round.
Yes.
Yes. Okay.
And in addition, there were estimated to be costs and expenses of about 100 million in an insolvency scenario. Both of those figures one actually gets from the BCG report, which is in the supplemental bundle, page 34. I won't take you to it now, but that's where those numbers come from. And what that does is create an enormous delta between the relevant alternative outcome and the plan outcome, no matter which of the underlying valuations are used. So if everyone gets paid in full, that's fine. If the valuations are out and there's an enforcement, well, at least you then avoid this enormous insolvency discount, and everyone is better off. And there's therefore just no basis for suggesting that the 2029 note holders will be worse off under the plan than in the Knight Frank valuation scenario. And we cross-examined Miss Rickleton on this point, and we suggest that she didn't really have an answer to that. As you can see from the judgment, she originally gave an answer, but that involved what the judge rightly held to be an error in the way that she calculated the returns to the creditors, because she was not comparing apples with apples. Can I ask your lordships, please, to read paragraphs 282 to 283 to yourselves, please. Now, ultimately, my learned friends quibble with certain aspects of the judge's analysis, but they're not really able to develop a case that the 29 note holders would be worse off under the plan in the Knight Frank valuation scenario than in the relevant alternative. They're forced really to argue that there was insufficient evidence for the court to reach that view. But ultimately, the significance of all of this is that first, the alternative case was not a necessary part of the conclusion that the no worse off test was satisfied. And secondly, its utility is in the judge thinking through, well, if he was wrong on the valuation, what would happen and how would the plan creditors fare? And part of his reasoning for exercising his discretion in the way that he did, because he was satisfied that the most likely outcome was payment in full, and on a balance of probabilities that would be what would happen. But failing that, it wouldn't be the doomsday scenario that Miss Rickleton referred to. It would be an enforcement scenario where the differences between the 25 and the 29 note holders' rights would be, in a sense, equalised. They would be able to avoid a 23 to 25% insolvency discount on the assets, and they would be better off. And therefore we say that ground 7 should be rejected in the sense that this analysis was not critical to the no worse off test, but that also it was necessary to go through that exercise so that when your lordships come to revisit the exercise of the discretion as explained by the judge, you can see that the basis upon which he reached his conclusions as to the likely outcomes were not finger in the air stuff, but based upon a careful analysis of the rights that the plan creditors were given through the plan. I see the time. I've only got ground 8 to cover. Can I, unless your lordships have any question, turn to ground 8 and then give way to my learned friend for his reply?
You have ground 8 to cover. I think we'd also like you to address the question we asked Mr. Smith, which is what do you say should happen if the appeal is allowed?
Shall I deal with that first?
Well, up to you.
I'll deal with that first. I mean, one thing that's difficult is to know the basis upon which the court makes its decision. But let's assume the court decides that the exercise of discretion was wrongly carried out. Then, in my submission, this court can re-exercise the discretion. There's no need for the case to go back to the judge. If the court were to re-exercise the discretion in favour of sanctioning the scheme, then no order would need to be made, the sanction order would remain. If the court decided that it was appropriate to re-exercise the discretion and find that the judge should have refused sanction, then this court should make an order setting aside the sanction order.
And no other order?
No other order. What flows from that will then be determined elsewhere with reference to the steps that have been taken, the basis upon which they've been taken, whether it's pursuant to an authority granted by the plan or not, and the consequences that follow from that, which may be the subject of a hot dispute in Germany or elsewhere.
Or indeed here.
Or indeed here.
I think what you're saying is it's not for us to worry about what the practical consequences might be if we think the appeal should be allowed and no sanction given to the plan. We simply set aside the order and you have to live with whatever that means in practical
That's right.
terms.
We do not advance a case.
Yes.
That if the judge got it wrong and this court should, and find that he should have refused sanction, that because it leaves a mess or uncertainty,
that's not a reason.
That
yes.
the sanction order should be left in place. We do not say so.
Putting it very broadly, Mr. Smith said, look, the essence of the plan is to reorganise the position of the Sun note holders into say, you, the company, have received new money pursuant to the new money facilities, and they may or may not stand as facilities independently of the setting aside of the order. And then how that is sorted out is not for us.
And it does not matter, Mr. Bedfield, but I think I did have a note that I thought the judge's paragraph 178 was the wrong way round. If you compare it with page 34 of the supplemental bundle, which sets out the insolvency discussion.
Are you talking about the numbers?
Yes.
I see. I thought you meant that he'd said it would... I would need to double check. I'm sure if my lord says he's got the numbers the wrong way round, then I'm sure your lordship is right.
I think what the BCG report shows is 500 million reduction in the development assets.
And a larger one for the yielding assets. That's instinctively more likely to be correct. I'd misunderstood my lord in terms of how he got it the wrong way round.
I don't think it affects anything.
It doesn't. It doesn't. Then, my lords, very briefly, ground 8. Now, here the appellants contend that there was a blot on the plan, or that the plan would be unlikely to have substantial effect because certain of the note holders had purported to accelerate their notes. Now, as my Lord Justice Snowden made clear in Virgin Active and elsewhere, a blot is a technical or legal defect in a plan or scheme, such that the terms are, for example, rendered inoperative or ineffective by virtue of their infringement of a mandatory provision of law. That's the, I'm going to say, non-exhaustive definition that my Lord has given of a blot. And the reference is paragraph 313 of my Lord's judgment in Virgin Active, Authorities Bundle 2, tab 28, page 928. We query whether the argument really is a blot argument rather than a substantial effect argument, but it probably doesn't matter much quite how one pigeonholes it. The argument is...
So, I've sometimes said the scheme or the plan doesn't do what it says on the tin, or doesn't do what everybody expects it to do, because there's some insuperable barrier in the way.
Yes, it is capable of being undermined in a way which causes it not to be effective.
I mean, one of the ones in the past was in T&N was the question about whether the scheme infringed a mandatory provision in relation to the third-party rights under insurers, against insurers legislation, for example, I think, which Mr. Justice David Richards sorted out.
Yes.
It's that sort of thing.
It is. This seems to me to be slightly different from that. If my lord thinks about the evidence that is required for international recognition, that's required to ensure that the court's not acting in vain, that the scheme or plan will have serve a substantial purpose, have effect. I think what this point really is well, the plan doesn't work because it's undermined by the fact that there are certain note holders who have accelerated and are entitled to enforce their rights. And therefore the plan doesn't work. And I think that's really the argument that I need to address.
It's somewhat similar to the argument that was run in APCO, as I recall it, which is, doesn't matter what we do here, if the German courts won't recognise and allow people to enforce their pre-existing rights against assets in Germany, then what's promised to people under the scheme or plan just
exactly.
It's rich in water, as it were.
It's another example of what Mr. Justice David Richards, as he then was, said in Sompo, that the court won't act in vain, and it looks to see whether the scheme is going to work. It doesn't have to be sure it will, doesn't have to work perfectly, but is it going to serve a substantial purpose? That was the approach that his lordship took in that case, and that's really the starting point for why everyone puts in evidence on recognition in the jurisdictions that matter. Now, in this case, the amount said to have been accelerated is approximately 185 million of the 3.2 billion of notes. Now, there is a dispute between the company and the note holders as to whether or not the notices of acceleration are valid and effective. The note holders rely upon the provisions of the plan as being an event of default, which entitled them to accelerate their note under the terms of the sons themselves, and the company denies that the promotion of the plan amounts to an event of default. Now, that issue is an issue of German law. It turns on the true construction of the terms which govern the sons.
When you say the promotion of the plan, do you mean the mere fact of putting it forward, or do you mean the sanctioning of the plan?
They, I think, rely upon the plan having been put forward because they accelerated before the plan had been sanctioned. This was the subject of expert evidence of German law, which there was insufficient time for the judge to deal with at the trial. The argument was, in effect, whether under the event of default provisions under the sons, the particular German term for insolvency proceedings captures a restructuring plan or not. The Ad Hoc Group's expert said that it did. The company's expert said that it didn't. It's not answered by what Mr. Justice Zaccarulli said in Gate Group, because what matters is what meaning you give to the term insolvency proceedings in that contractual context, and that was the dispute that has arisen between the experts. Now, in Learned Friends' appeal skeleton, at paragraph 63, they said, it will therefore be necessary to pay these creditors in full. This is inconsistent with the terms of the plan. Moreover, there was no evidence to suggest that the group will be able to pay the creditors in full and proceed with the realisation of properties on the timescale envisaged in the management case. In the circumstance, the judge was wrong to conclude that these matters did not amount to a blot on the plan or reason why it was not reasonably likely to have substantial effect. Now, the answer to that is, well, firstly, that assumes, as their submissions assume, that the enforcement was valid. And as I said, that's an issue of German law which wasn't determined by the judge. And in fact, the accelerating plan creditors have so far as I know, not taken any steps to seek payment or to commence proceedings in relation to their accelerated notes in Germany, notwithstanding that they accelerated back in, I assume it was March or April. Were they to do so, the company would defend the claim. It would take some time for that to be resolved, including potentially 1 or 2 appeals. And ultimately, what the judge decided was, given the amount at stake and given the time frame over which the issue might be debated in circumstances where there are no proceedings even commenced yet to resolve it, he couldn't see how that was going to scupper the effectiveness of the plan. As we've explained in our skeleton, the company is confident of its position in relation to the issue of German contractual construction, but in any event it's going to take a considerable period of time from the commencement of proceedings for the issue to be determined. There are then going to be issues which would arise in relation to whether the note holders, if they have validly accelerated, are entitled to take steps to enforce, and what the role of the notes representative in that context may be, if any. The judge's reasoning on this is set out at paragraphs 337 to 339. So pages 917 to 918. We submit, and I'll invite your lordships to at least skim read those paragraphs, that his reasoning in this regard is entirely correct.
You say if this is properly characterised as a does the scheme have substantive effect type question rather than an English legal obstacle,
Yes.
that the judge exercised his discretion on, by evaluating what would happen in the 2 relevant alternatives in Germany, and in the absence of any determination of the German law, and the fact that therefore he didn't determine the German law question himself is neither here nor there.
That's right. And if in 3 years' time or whenever it is, these note holders establish that they're entitled to be paid and they've effectively jumped the queue, well then an asset disposal programme of billions of dollars worth of assets will have been conducted over that however many year period. And it would be wrong to assume that the company would be unable to make the payment, which is the ultimate worst case scenario from the company's perspective. So did the court act in vain in sanctioning the plan because of this purportedly accelerated debt? Answer, no.
I always think that test probably, I know everybody always uses that wording because it's the highest you can put it if you're promoting a plan. Because put in that way, it's quite a high burden for an opponent to surmount. I mean, it's more evaluation of the likely effectiveness of the plan, given what's been said to creditors and what might happen. I mean, that is a genuinely evaluative exercise. There's no bright line.
There is no bright line,
I can put that way.
and the judge exercised his discretion in that regard perfectly properly. That's ground 8. Those are our submissions, subject to any questions that your lordships have for me.
No, thank you very much.
Thank you, my lord.
Smith.
Thank you, my lord. I'll be relatively brief in reply. If I can deal first with the points arising in relation to discretion for cross-class cram down. The first point is the framework for the exercise of the discretion. My learned friend accepted in his submissions that, to use his words, the starting point is the relevant alternative when it comes to exercising the discretion. In our submission, that's correct insofar as it goes, but we would put it slightly differently. We would say it provides the framework for the analysis, or in other words, the reference point. And just to make one point on this, which may be an obvious point, but I don't want it to escape your lordship's attention, it's very important that the concept of the relevant alternative is referenced and indeed defined in section 901G. If you will recall, in the legislation, and perhaps it's worth turning this up, section 901G is obviously the core provision which we're concerned with, because that's the cross-class cram-down power. And you'll find it in the authorities bundle behind divided 2, it's page 38. And the concept of the relevant alternative is introduced specifically in 901G in the context of condition A, and then you'll notice it's then defined in subsection 4. It's quite interesting to note the opening words of subsection 4 for the purposes of this section, not merely subsection 3. So it's the statutory concept, it's explicitly the reference point for the satisfaction, judging whether condition A is satisfied or not. And in our submission, it would be extremely odd if it wasn't also the reference point for judging the exercise of discretion and the extent to which the plan is doing something differently from the relevant alternative, and then asking oneself, well, if it is there a justification for that? And indeed, not only is it referenced in the legislation, in our submission, ultimately, there just is an inherent common sense in making the comparison against the thing that is most likely to happen absent the scheme. And even if this wasn't referenced in the section, the common sense reference point is the thing which is likely to happen.
Well, it's the reference point that runs throughout the whole regime, isn't it? Because in the same way as when you look at classes, you've always looked at, in an insolvency context at least after Hawke, you've always looked at the relevant alternative, yes. Although people didn't coin that phrase, nor Justice Chadwick didn't use the word relevant alternative, but it's always been what would be the position if the plan was not sanctioned.
Yes, exactly.
The scheme in that case in Hawke, and it's the basis for the class definition in schemes, and it's also, I think, isn't it, the basis for the power to drop people out of class meetings in plans if, in the relevant alternative, they would have no economic interest.
Exactly right. That was the other point I was going to make. Your lordship's absolutely right. If you go to 901C4, page 31, which uses the concept of genuine economic interest in the company, we know from the case law that that's assessed by reference to the position in the relevant alternative.
Yeah, which goes back to the scheme cases, saying if you're out of the money.
Yes.
This is a nice way of saying you're out of the money.
Exactly. So
you can be left behind.
So in our submission, that is the framework, and we do submit the judge went wrong as a matter of principle in paragraph 302 sub 1 and 306(2) by focusing on the position in relation to the contractual maturity date rather than the position in the relevant alternative. And that was an error of principle that he made, and in our submission that affected his approach in both of those core paragraphs of his judgment. So that's the first point. And the second point is it's common ground, obviously, that the plan departs materially from that
framework. My learned friend accepted fairly in his submissions, to use his words, he accepts that plan creditors do not receive equal treatment under the plan. And that's accepted, that's common ground. Your Lordships have the point, but the core paragraphs of the judgment for our purposes are 291, 300 and 301, against which there's no challenge. And we rely on those paragraphs as demonstrating, as a matter of fact, that my clients, the 2029 sun holders, bear greater risk under the plan, as the judge himself held. In addition to that, the departure from pari passu by reason of the grant of security is obvious. So the next question is, well, where does that take one as a matter of analysis? In our submission, it does take one to paragraph 74 of the judgment at page 784. Now, in my learned friend's skeleton argument, he accepted this is the correct test at paragraph 14. He then, I think in his oral submissions, sought to row back from that somewhat. One can understand why he sought to row back from that, because the moment you accept that's the test and then compare it to what the judge in fact did in 302 and 306, you can see why that causes a huge difficulty for the plan company's case. But in my submission, there's no basis for rowing back from this. The point we would make is that although the judge doesn't cite authority in that sentence at the end of paragraph 74, this is not something that is the judge's invention, this principle that he identifies there. He's distilled that from the case law, and in particular, if you look back in the preceding paragraphs of the judgment, the immediately preceding paragraphs of the judgment, it's a point that comes strongly out of the CVA cases, of which there's a rich stream of authority. Although he doesn't cite it in the scheme of arrangement context, it goes back probably in the modern incarnation to Garuda as the first case, and the case that followed from that. So this isn't a sort of, it isn't the judge's invention, this point. In our submission, it reflects actually a long-standing strand of authority. And
there is a decision of Mr. Justice Newberger, as he then was, in a insurance company run-off put forward as an alternative to a conventional liquidation, where the issue was whether you could depart from the pari passu rule and insolvency set-off.
yes,
and again, I confess I was the counsel in it. Mr. Justice Newberger said, yes, it can be done. I think he put it as high as the court would have, it would be an exceptional case in which the court would.
yes.
But in any event, you say good reason is a good enough test.
Exactly, and we submit that is that is perfectly good formulation of the test. And in our submission, where the judge has gone wrong on this part of the case, it is simply not applying that by the time you get to paragraphs 302 and 306. And indeed, it's. I mean, what is ultimately remarkable about this case in our submission is there isn't actually a good reason or proper justification put forward even now for the lack of equality of treatment in terms of the allocation of risk, of repayment and the grant of security for the 2024.
I know you say that the reasons that were put forward, or the basis that was put forward, isn't a good one or a proper one, because it focuses on the wrong alternative, the wrong comparison.
Correct.
So that, in a sense, that's all you need to say, or you say that's all you need to say.
Yes.
But actually, the words "good," good reason or proper basis, sort of rather beg the question as well, don't they? I mean, you've at least said yes. There's a frame of reference to pari passu, but then how do you? I mean, are you prepared to sort of venture a view as to what good reason or proper basis actually means?
Yes, I am. So, I mean, good reason would be where, for example, you need to pay someone in full in order to preserve or create value for the benefit of creditors generally. So, if there's some reason why you need to treat someone in a non-pari passu way, because that is in the collective greater interest, then that may be justifiable. And you see that from the sort of cases where employees are being paid in trade creditors being paid in full, because the idea is, well, if you pay those, although you're benefiting them, actually it creates a greater benefit for the common good. Put it that way. So that would be a good reason. I mean, a proper basis is perhaps a little more difficult to identify, but I accepted, and indeed I submitted to the judge that in this sort of case where you've got a liquidation plan, if the judge had been 100% satisfied that we were going to be paid in full in 2029, well, there probably wouldn't be anything to complain about if he was satisfied 100% that we would be paid in full. I mean, you may say, well, that's a wildly unlikely scenario, but that may be a case where there would be a proper basis.
Yeah, so that's why you say this case is all about risk allocation.
Exactly, but fundamentally this case doesn't get there, and that's, I mean, 301 is perhaps the crux of the judgment, because I made that submission to him, which he didn't accept. He did say there's greater risk, correctly, but then he didn't follow that through in identifying what the proper reason and what the good reason or proper basis was for heaping that risk onto us.
So good reason, you say, in a sense, it's some external or some reason which adds to the greater good. So
yes.
I mean, you could, for example, so you say paying employees, paying critical trade creditors, giving priority to new money. Sorry,
yes.
Giving priority to people who put in new money.
Correct.
But I think your point is in relation to this plan, the reasons advanced for the differential treatment of the Sun note holders had nothing to do with externalities of that sort, adding to the general good of the creditor base.
Yes, they're completely irrelevant, because this is a liquidation plan, so you're not making those external payments in order to preserve or generate value for the greater good. It's just a liquidation plan, so it's all about the manner in which you do the wind down. That's all it is about.
Yeah, well, the point is that the new money you need to carry out that wind, to finish the development, to carry out the wind down, is compensated for by the provision of enhanced security for that new money.
Yes.
And everybody gets a chance to put in for it.
Exactly. And we haven't taken issue with, as I made clear in my opening submissions, the grant of the new money coming in and the principle of that being used pro tanto to discharge the debt lower down the group. I mean, one can see why that part of it is justified. We've taken objection to the cost of the new money and the, if you like, the ancillary costs as a result of the new money. But that, in principle, the new money coming in and you getting the euro for euro benefit wouldn't be objectionable. But what is objectionable is, once you put that aside, why is it that the maturity dates are not equalised when there's absolutely no reason why that was required for the purposes of this wind down plan? So fundamentally, I mean, we do submit this. It's actually a quite remarkable case in the sense that the inequality of treatment doesn't even really come close to having any justification.
Was Mr. Justice Saccarelli wrong in Rehust?
No, I don't. I mean, let me turn to Rehust. I think.
I mean, he says the things you want him to say.
He does. He's right. It's on the law.
When it comes to actually doing it, he does impose an unequal treatment on HMRC.
He does, but
and it's not very easy to see what good reason there is.
I mean, I think there's ultimately there's perhaps a limit to how much more reliance one can place on the outcome of the case, given it was an unopposed application. And that's obviously one of the reasons he relies on. But the other core reason he relies on, if you go to paragraph 40 of Who's, page 1061. I mean, paragraph 40.
You're getting new money at
it
enables you to trade.
Exactly, but it seems to us paragraph 40 is critical, because the new value generated as a result of the plan, so in other words, the restructuring surplus, comes effectively from new money put in by the shareholders. And then he goes on to say, in the last sentence of paragraph 40, it's not therefore a case where assets that would have been available to the administration of the company are being applied in a manner inconsistent with the order of priorities applicable in the administration.
That's generating new assets.
Exactly.
And whereas in your case, you say the assets, there's no new assets. The assets are the same. It's
Yes.
just they're being sold in a more advantageous way in a wind down.
Yes.
But that's not a sufficient reason to.
It's not, because you could, the core point is you could achieve that more advantageous realisation in a way that doesn't involve giving different maturity dates. You're back to the core point. The core point in all of this is the objectives of this plan could easily have been met by not giving security to 2024s and having equal maturity dates, so that everyone just shared in the realisations as and when they were made, and you would have avoided any need to go into insolvency. You would have avoided any need to rush to sell the assets. You could have brought the new money in as well. The treating everyone equally in that way wouldn't have precluded bringing the new money in. So fundamentally, what makes our case remarkable in our submission is that there was no reason, by reference to the objectives of this plan, why one had to depart from the pari passu. And that is the fundamental point in this case.
No good reason, I mean, to go back to paragraph 74, no good reason in the interest of creditors as a whole.
Yes. Yes.
To depart from the plan. I mean, the good the good reason in relation to creditors as a whole is something that is satisfied in all the other examples you've given. But in any event, presumably, you don't suggest that Mr. Justice Acquarelli was wrong in his statements of principle.
No, I think we say he's right in his statements of the law and principle, yes.
Whether he applied them correctly or otherwise in that case is not.
I mean, it doesn't take matters much further. I mean, I don't think I need to submit it was wrong. I mean, I can see why he did come to the judgment he did respectfully. And the key point is, I think, for the reasons he identifies in paragraph 40 onwards, our case is fundamentally different. So that's how. So far as the vote's concerned, I mean, there's a similar flaw in our submission with the judge's approach in that in paragraph 66 he puts the test, if you like, in a way that is difficult to quibble with. I mean, I think we've said he puts it correctly by saying I approach the question of discretion on the basis that overall support is a relevant but not decisive factor. I mean, he doesn't discriminate there between the assenting and the dissenting class. But then, in our submission, when you get to the later paragraphs, I mean, contrary to my learned friend, we do submit that a fair reading is that he does put a lot of weight on the 62.1% vote in the assenting class. I mean, if you read those paragraphs and the judgment as a whole, and then look at what he says, and you've also got the extract I showed you from the transcript of the permission to appeal hearing, I mean, a fair reading is he puts a lot of weight on that in our submission. So again, he maybe said he didn't follow through on what he said earlier in the judgment. We do submit that it's questionable how much weight one could put on that. You've got the cross-holdings point. I mean, in terms of what creditors were told, on the financial information as to the returns under the plan, the only figure they in fact had was BCG saying everyone would get 100 cents in the pound, so 100 cents in the euro. That was the only figure that was put to them. There wasn't even a sensitivity analysis that says if we're out by that, you might get that much less, or if we're wrong the other way, you get that much more. The only figure they saw in the plan and the explanatory statement was 100 cents in the euro.
But it's not difficult, if you read the BCG report and you know what you're doing, to work out that that's dependent on a particular level of proceeds, and there's only headroom at that stage of about 400 million. And
you can work it out, but it was put
and it's not difficult to work out what will happen if that happens. If there's a shortfall, who bears the risk of a shortfall?
Yes.
Your clients worked it out.
Well, we did work it out. I mean, we've got 235 million euros of exposure in this class, and we were in a position to commission Knight Frank and FTI to look at it. So we were obviously in a position where we have the resources to do that sort of work, and where we were incentivized to do that because we have a lot of skin in the game in the 2029s.
But you don't need to commission experts in order to appreciate that if you're valuing real property, which depends upon yield, well, it depends upon the yielding assets, it depends upon the market rent, and it depends upon yield, and both of those are variables which you can't guarantee. Far more so with residual valuations of development projects, where even small differences in input can lead to very large differences in outputs. And everybody in this world will know that.
You can work it out, but the only figure they had was 100 cents in the euro, and the explanatory statement explicitly was put on the basis the plan company anticipates that the plan creditors will be paid in full. I accept if you work it out, you sit down, you think about it, you go through the BCG report, all of those things the Lordship's mentioned will become apparent. But in our submission, the critical bit of information that was missing was the bit of information, and particularly so far as the 2029 is concerned, of being told that the unequal allocation of risk wasn't something that was necessary. That's the critical bit of information from their perspective, and that, in our submission, makes all the difference to the decision in the 2029 whether or not to approve the plan. Because it's one thing to vote in favour of the plan, and you think, well, if this is the only way it can be done, that looks better than the liquidation, and I'm going to take that. I'll take the risk. If it's better than the liquidation, well, so be it. If you're told, well, actually, that's not the only way we can do it, we can also do it this other way, and in this other way, everyone bears the risk equally, what are the 2029s going to do then? They're going to think, well, why aren't you doing it that other way? And that's the critical bit of information that was missing from this, and means why the 2029 creditor vote needs to be treated with a little caution, perhaps more than a little caution.
Well, just how much do you need to spoon feed people? You put forward something which you can work out if you spend a little bit of time means that the 2029s bear more risk than other people. And you can see, because it's not there, that no particular justification is put forward saying this needs to be done because surely you can draw the inference for yourself that there isn't any particular reason why it needs to be done. You have to be told that.
Well, I think you do.
If you're given a list of risk factors, which includes some blindingly obvious ones, why? I mean, the one alternative point is, why wasn't this on there?
Yes, I mean, this is from the 2029s. It's almost the core bit of information, I would suggest, because if they're told, well, actually, we can do all this, but you don't need to bear this risk, then it becomes a very different choice for them, ultimately.
Well, what it would have said, if it had said more, is that this is a result of a commercial negotiation, and that's, you know, I mean, that's the justification that's put forward to the judge. That's if more had been said in the explanatory statement, that's what would have been said.
Well, it's not so much as it's being told that actually the inequality treatment isn't necessary to achieve the objectives of implementing the management case. I mean, that's you don't need to do it this way in order to implement that management case. And that is in my submission, the critical bit of information. And related to that, I mean, we do submit that it must be questionable how much time someone with pretty small holdings, like 100,000 euros,
Understand.
spend.
Can I ask, is this a freestanding objection that the plan is flawed because the explanatory statement's not good enough? It's simply to undermine the weight you place on the voting. Is that
Correct.
it? Yes.
Correct. And indeed, our primary submission on that, which I made yesterday, is ultimately our main answer is, well, if the plan's unfair, a vote in the dissenting class, which is less than the statutory majority, isn't something that makes it fair, and therefore you don't even actually get to this question.
Because as soon as you get less than 75%, you open the door to the court's discretion, and the court has to exercise its discretion having regard to all the factors.
Exactly, it's a decision for the court, not for the rump majority in the dissenting class.
If you put it all the way back to the old cases in Telewest under schemes, one of the conditions is that the creditors have to be properly consulted
Yes.
before the court can take the view that they are the best judges of their own commercial interest.
Yes.
It's sort of
It's the same point.
it's tied up with the force that you can give to. I mean, there are two ways an explanatory statement can be wrong. One is it can just be wrong, just inaccurate and misleading in a positively bad way, omitting critical information, critical evidence necessary for the reaching of a decision.
Yes.
Alternatively, it can, if you were prepared to scrabble around in it, may give you all you need to find. But then you have to form a judgment about whether you can rely upon the affirmative vote, or in this case, the non-assenting vote,
Yes.
as an indication of the commercial interests of creditors.
Yes. Yes. I agree with that, Lord. So, my Lord, I was going to then bravely attempt to pick up the gauntlet on the allocation of the equity point. As I understand, my Lord's point is essentially on the meaning of arrangement in section 901.
Well, was I right up till there, in the sense that when I was reflecting on it, my understanding of your case is that what you complain about is that the equity holders were allowed to retain their shares.
Yes.
And so the flip side of that coin is that you say that the plan should have provided for their shares to be taken away from them.
Yes.
And distributed amongst the creditors who were in the money.
Yes.
And I said to you, well, what mechanism could be used to achieve that? Because
Yes.
that would plainly, if you're going to, I can't think of any obvious mechanism under the Companies Act. You're not planning to leave them behind in the shell, which
Yes.
is the old device. Therefore, you have to bring it under section 901.
Yes.
And therefore it has to be a compromise or arrangement between them and the company. And traditionally that has been said under the scheme legislation, under the scheme jurisdiction, to require an element of give or take, albeit broadly construed, but certainly it does not include an expropriation for no consideration. And in Smile Telecom, you got your plan through.
Yeah.
Because you provided a nominal consideration, therefore I didn't have to actually grapple with the possibility that you'd be trying to take out shareholders for no consideration, or take out people who are out of the money anyway, because this would apply to creditors who are out
Correct.
of the money as well.
Correct.
Mr. Justice Richard Smith was persuaded, for reasons he set out in Prezzo,
Yes.
that you could take out people who are out of the money for no consideration. In other words, you could just extinguish someone's debt if they were out of the money as part of a plan.
Yes.
And it would be the same. You'd actually have to provide in a plan with members that their shares should be transferred pursuant to some attorney
Yes.
for no consideration.
Yes. Correct.
Right. So we are on the same page.
We are on the same
Yeah.
page. And in my submission, the Prezzo was right on this point. So it's paragraph 43 of Prezzo. Just to give your lordship one other case, it was not just Mr. Justice Smith. I don't think we have it in the bundle, but Mr. Justice Trower in the Great Annual Savings Convening Judgment will provide this to your lordship at paragraph 6, 26 of 6 and 26 to 30. Also looked at this point, didn't have to decide it, but I think it's fair to say he thought it was probably right.
Because the curiosity is that people, to the extent I decided to leave it open,
Yeah.
I certainly wasn't giving a green light to this argument. In Smile, I genuinely didn't have to decide it.
You didn't have to decide it in Smile.
So,
And Mr. Justice Trower didn't have to decide it in Great Annual Savings either, but he said, I think there's real substance in the force of the submission, that you don't need give and take in an arrangement under a Part 26A plan with out of the money creditors or shareholders. So far as Prezzo is concerned, that's in the Authorities Bundle 2, paragraph 43. Prezzo is at tab 40.
In fact, just to be clear, you can see probably as a fair summary, it's certainly a summary above. The words give and take a little bit. I think it's really saying that the word shouldn't be given a narrow meaning beyond indicating it cannot amount simply to a surrender or confiscation.
Yes, exactly.
I mean, that's Lehman Brothers International Europe number 2. What was that one? That's Mr. Justice Hilliard, is it?
That is one of the Lehman. My own friend will know better than me. I think that must be one of the Lehman schemes, Mr. Justice Hilliard.
So,
I mean, it obviously comes from NFU development. Is the
it does.
yeah.
Yeah.
So Mr. Justice Richard Smith decided this, and in my submission, he was right to do so in the way in which he did. There's 3 points I'd make. The first is that under Part 26A of the Companies Act, the Restructuring Plan legislation, under Section 901C4, the court can disenfranchise a creditor or member who has no genuine economic interest in the company from even voting. That's undoubtedly the position, that's the power that was introduced in Section 901C. Now, in our submission, it would be somewhat odd if you could disenfranchise someone from voting because they have no genuine economic interest, but at the same time, you were still required to give them something of value in order to remove their rights under the plan. In our submission, that would be an inconsistency of approach in the legislation. It wouldn't make much sense if the legislation is saying in Section 901C, you don't even need to consult these people because they have no genuine economic interest. But on the other hand, by the time you get to 901F and G, to say, well, actually, no, you have to give them something in order to have a valid arrangement, that would be an inconsistency. It would be
No, in order to have a valid arrangement under which you expropriate
Yes.
their shares.
Yes.
I mean, if they're not affected.
No, but under 901C, you exclude them even if they are affected.
Yeah,
Yeah.
But I mean, there's a distinction, isn't there, between, as it were, leaving the members unaffected by the plan.
Well, if they're unaffected, you don't need to join them. So, I mean, let's look at 901C. The whole, obviously, what 901C says
could
is...
this be done could this be in effect simply saying, in the same way as you don't need actually to make them parties to the plan in the first place, if
Well, I mean, if you look at 901C, on page 31, I mean, there's the two limbs to what was introduced as part of the amendments through Part 26A. The first is subparagraph 3. So they added in this requirement that every creditor or member whose rights are affected by the compromise must be permitted to participate in a meeting. So under subsection 3, if you've got a shareholder whose rights are being expropriated, then prima facie they are entitled to participate in a meeting. But that is then subject to subsection 4 that says, nonetheless, if they don't have a genuine economic interest in the company, you don't have to have a meeting. So if you apply those to a shareholder whose rights are being expropriated under a plan, but who have no genuine economic interest in the company because they're out of the money and the relevant alternative, you don't need to convene a meeting of them. They're in effect disenfranchised. So my point on this is my first point. My point is there would be an obvious inconsistency between being able to do that in relation to voting and the legislation in effect saying they're out of the money. It doesn't matter. You can do what you want with their rights. They're out of the money. You don't even need to call a meeting of them. But at the same time saying, well, actually, you have to give them something. It's a tension. The second point is on 901G and on page 38. And what's relevant on this is condition A is put in terms that none of the members of the dissenting class would be any worse off. Now, if you imagine that you do actually proceed to have a meeting of shareholders who are out of the money, but nonetheless you have a meeting, and they vote against, they're the dissenting class, all that's required in their case for the cram down power to become exercisable under 901G3 is that they receive nothing. Because if they're no worse off. So the legislation, the way it's framed in condition A, doesn't actually require you to give anything to out of the money creditors or shareholders. Now, in our submission, again, there would be a bit of a tension if the legislation has set the bar in 901G3 that low for the condition to exercise a discretion, but then through the back door of the definition of arrangement says, well, no, actually, you do have to give them something. And again, there's a tension. And then the third point is just a point which arises out of the legislative materials, and this is Authorities Bundle 1, page 108. So if you go to tab 6, page 102, this is one of the legislative materials. This is the House of Commons briefing paper. If you go to 108,
is this something we can look at? I mean, does this?
Well, it was put in the bundle.
Does it fulfil the sort of general requirements for looking at legislative materials? It's not an explanatory note. It's not a.
No, it's not. That's true. I mean, that's yes. I mean, we're slightly hamstrung in dealing with this point in the sense that I think there are explanatory materials available which would shed light on it. If I can just explain what the point is, and perhaps we don't need to look at the material for me to make it. As your lordship said earlier, before the restructuring plan mechanism came into place, the way in which you could do this sort of expropriation was through a pre-pack administration company.
Yes, although you didn't in fact expropriate the shares, you just left them behind.
You left them behind in an empty shell.
But that's a fairly important distinction.
Well, it is.
Because you're not actually taking away the right of property that constitutes a share. It's just said to be appropriate or legitimate to take the assets out from the company leaving a shell.
Yes.
Your proposition is that the plan allows you to go further and actually take out a right of property. And in fact, I mean, just to be very clear about this, why this is an important point, it's not just dealing with equity. This question applies also to all the out-of-the-money creditors.
It does, yes, absolutely.
And what I understand is happening in a number of plans is that out-of-the-money creditors' claims are being eliminated and compromised for nothing.
Yes.
Leaving the company against which those claims would have been capable of being made debt-free in that, so far as that
class is concerned, yes.
To the enhanced value of the people who continue with the company.
Well, yes, that may be right. To the enhanced, I mean, if they're the in-the-money creditors, they would get the benefit of the surplus.
This is.
But that's no different from what happened previously when, I mean, that would be the end result of doing a pre-pack with a scheme anyway.
Can I ask a different question?
Yes, of course.
The power of compromise or arrangement is between a company and its members or creditors.
Yeah.
These people who have the equity in the parent, neither this plan company's members nor its creditors.
Well, so this is a separate point, and
it is a separate point.
It is, and this goes to a similar point, but in my submission, that point on the facts of this case can't be an answer, because the only reason why that point arises is that the group has used this device of putting forward the plan through, in effect, this special purpose vehicle they've incorporated in England. They've done the issue of substitution, and then they say, well, because we're using this special purpose vehicle, that means we can't do anything in relation to the CM's tough. We can't do anything in relation to the equity tough.
Also, how are you saying that they should have resolved the problem my lord's just identified? What mechanism could they have used to expropriate the shares of the existing equity holders?
Well, they'd have had to have done on this, having set it up the way in which they have, using this special purpose plan vehicle. They've effectively hamstrung themselves, because once you use an SPV, then obviously the equity in that particular company is irrelevant, probably. What matters is the equity in the parent company. And my point is, well, it can't be right for a group to come along and effectively create a special purpose vehicle, by one means or another put the relevant liabilities into that vehicle, then do a plan or scheme of that vehicle and say, well, we're sorry, we can't do anything about the equity because the equity is elsewhere. I mean, it may be the answer would be, well, that just...
Well, who holds shares in the plan company?
The plan company, I think, would be
the parent.
Would be a subsidiary of the parent. But the plan company has no value itself. I mean, this is just a vehicle. I mean, it doesn't... The assets of this group don't sit underneath the plan company.
We were told it has no assets.
Yes, it's just... I mean, it's an SPV. It's just a vehicle. It's just been created.
It's a jurisdictional device.
It's a jurisdictional device.
So you are saying that they ought to have found a mechanism to expropriate the shares of the
Yes.
parent company and transfer them to you?
Yes. And my point on this is it can't be an answer to my point for them to say, aha, we can't do anything.
But what is that mechanism?
That mechanism, well, they would have to have done a German SteerCo potentially, or sought to do a restructuring plan of the parent company. But I mean, in essence, it can't be an answer to my point for them to say, well, actually, because of the way we've set it up, doing this jurisdictional device, that we can't do anything with the equity.
But okay, but I mean, either you're wrong on your proposition, in which case it's not a problem. If you're right on your proposition, you're asking them to do either something which is impossible for them to do, but you're not complaining about the transfer mechanism they've used. You know, the structure that they've adopted.
Well, I'm not challenging the issue of substitution on this appeal. But
so how can you then?
Because I'm saying it can't.
How can you then turn around and say, well, we don't object to the substitution, but we do say they should have found a way of.
Because it can't be an answer to. And what I'm submitting is it can't be an answer to our point about there is unfairness in the allocation of equity for them to turn around and say, well, actually, there's nothing we can do about it. Our hands are tied because of the fact we've used this jurisdictional device to come into this jurisdiction. I mean, that is just not a sufficient answer to our point. And it's actually their problem. If we're right that something ought to be done with the equity, then it's up to the plan company to put forward something that is capable of resolving that.
And did the judge deal with this point in the way that we've been?
Not in the depth we're dealing with it now. I mean, I don't think Mellifram raised this specific point. He didn't raise your lordship's arrangement point or this specific point. I think these points are both new. It's fair to say.
Yeah, they're not new in the world.
They're not new in the world. No, I mean, can I just go back to I was going to on the arrangement point, because I made 2 points. The third point I was just in the process of making, which is that. As your lordship said, prior to the restructuring plan, you could have done this through a pre-pack administration and the scheme. In our submission, one of the reasons why the restructuring plan mechanic was introduced was because that mechanism of a pre-pack plus a scheme was considered to be an unwieldy way of cramming down out of the money people. So one of the entire reasons it was introduced was to enable you to do this without doing a pre-pack, and that was the point you get from that page of the briefing paper. You may get it from other places as well. We obviously haven't prepared.
Well, I went at great length actually to do that in Virgin Active. If you remember all those paragraphs, all that screed.
Exactly.
Rehearsing, it's all there, I think.
It is. Your lordship's exactly. Yeah, your lordship's right. So, I mean, that's all I was going to say on the shell part. And obviously, this point about the meaning of arrangement is whether it's determinative of this case may be one thing, but it's obviously a very important point for the market at large. It's fair to say. So, my lord, I think just very briefly then, just completing the submissions. So far as the alternative case is concerned, the alternative enforcement scenario, although my learned friend takes issue with that description, there's two ways in which that is relevant. Probably the main way in which it's relevant is the way the judge used it to bolster his views, his conclusions on the pari passu point and the reasoning in paragraphs 302 and 306. In our submission, my learned friend's submissions haven't really moved the dial on that, because firstly, I think he accepts that it doesn't deal with the security point in relation to the 2024s. But secondly, I don't think he dealt with my timing point, which is that, and in some ways we consider this to be the more significant point, which is that the enforcement scenario may apply at any point in time, because it's entirely dependent on how property prices move. And the judge seems to have assumed that actually it would take place before.
He looked at the worst case scenario on the basis of ninth frank figures, and on those figures you'd breach the covenant straight away.
Exactly, but there's no reason why that would necessarily happen. It's at least equally plausible that you get the 2025s paid out, maybe something else, and then it's triggered at that point. So it isn't an answer to the pari passu point for that reason as well, and he doesn't seem to have appreciated that. We would suggest in his analysis. And then the final point, just on the ground 7 and no worse off test, I mean, very shortly, our point on this is that if the notes are accelerated, which is a necessary part of the judge's analysis, there's no reason to think that the relevant group companies wouldn't go into liquidation. Now, the plan company's own evidence was that would be the position absent the plan if the notes were accelerated. My learned friend in his submission says, well, it's different under the plan because the note holders have got third ranking priority security. To which one asks why? Why would that make the difference? If the group's got all these accelerated debt claims against it, why would it not go into liquidation? And my learned friend's answer to that was to say, well, they grant waivers and forbearances, but with respect, there is no evidence for that. It's just speculation. I mean, who knows in reality? The only bit of evidence we do have is the evidence that the group put forward that under the non-plan scenario, if the notes were accelerated, it would go into liquidation. And there's a certain sense to that logic, because if all of the debt becomes due and you can't pay it, well, it might be thought that you would go into insolvency at that point. So that, I think, is just the only. I mean, that is the core of the point on ground 7, the no worse off test. My lords, unless I can assist you further, those are our submissions.
Thank you very much. Well, thank you both very much, and the teams of people who've been working behind you. We will reserve our judgments. As you will be aware, the practice is to circulate our judgments in draft, which gives you an opportunity to correct typographical and other minor infelicities, but not to re-argue the case. It also gives you an opportunity to see if you can agree an order giving effect to our judgments, and the judgments will then be handed down remotely with no attendance. The drafts these days come with an embargo, which is both fierce and means what it says, as I'm sure you are very well aware. We have another point.
Sorry. Is there a chronology somewhere of the events that took place? It's a point I raised yesterday, I forgot to raise it again. Is there a chronology of events anywhere in this? And by events, I include, as well, when negotiations started, etc. I mean, was that dealt with anywhere in the evidence, or is there a chronology that's been produced for the court dealing with any of that?
Certainly not that I recall.
No. I don't think there is a chronology. I mean, if your lordship wants one, I mean, it's no doubt capable of being produced.
I mean, it would certainly, apropos the points that I made yesterday, it would certainly assist, I think, to see at least some.
So your lordship's concerned with the sort of the build up to the plan, and then the negotiation date of the PSL, convening hearings.
Yeah, and Mr. Bayfield, you see, referred to a
Consent solicitation in December.
Yeah.
and that must presumably have referred to something, which led
Yeah.
up to that. So have we just been left in the dark, really, as to how this all kicked off, if I can put it that way?
We will produce something and agree it with my learned friends and submit that to the court.
Thank you very much. Is there anything else?
My Lord, no, thank you.